Now, in today's video, we're going to be talking about an opinion that has just been handed down by the Ninth Circuit Court of Appeals. It is in the case of Teeter v. Lopez. Now, this is a challenge to a Hawaii statute involving butterfly knives. Now, yes, this just relates to the states that fall within the Ninth Circuit, but it does have broad national implications. Now, a couple of little disclaimers right off the very beginning. I am not an edged weapons expert by any stretch of the imagination. My area of interest has always been relegated primarily towards firearms. Like many of you out there, I do carry a folding knife. And for most people, that seems to be something that everybody carries as a utility tool and potentially something that could be used in self-defense. But that all notwithstanding, there was some question as to whether or not bladed weapons fall within the scope of the Second Amendment. They've always fell within the scope of the Second Amendment. In fact, I think we would all arguably agree that knives have been around a lot longer in human history than guns. And the Second Amendment does not confer a right. The Second Amendment recognizes a pre-existing right to bear arms for lawful purposes, such as self-defense. And up until 500 years ago, the arms that you would bear for lawful purposes, such as self-defense, were more likely going to be bladed weapons. So throughout all of human history, we've got these things, right? Hawaii, however, feels very uncomfortable with a particular type of knife, specifically the butterfly knife. Now, state laws are different all over the place. California has knife restrictions that, candidly seem a little ridiculous, but we have certain knife restrictions that, other states like Tennessee don't have, right? Hawaii has a slew of restrictions, and then they seem to have a particular animus as it relates to butterfly knives. Most of you have seen a butterfly knife before. Functionally, it's no different than any other type of knife, except the opening mechanism involves two handles bending back. Apparently, this is something that runs afoul of the good tastes of the legislature of Hawaii, so they had banned them. Well, there were a couple of citizens that wanted to buy them, but since there was this prohibition, they weren't able to, and they sued after New York State Rifle and Pistol Association v. Bruin. Now remember, we typically in these videos talk about Bruin as it relates to firearms, but it's not that limited. Bruin applies to all arms, including knives. So they sued, and in the district court in Hawaii, they lost, which is not terribly unsurprising given the fact that it's Hawaii. So they then appealed to the Ninth Circuit Court of Appeals. There, they won. Now, what was interesting in this opinion is, number one, how Hawaii was attempting to target this case, how they were attempting to say that their state law should be upheld. And the first thing they did, like many states do, is claim simply that the Second Amendment doesn't apply. Specifically, and this is really interesting, they said that the people that, the Second Amendment applies to. Remember, when we do our analysis, we start with that threshold question, has the Second Amendment been implicated? Then, assuming it has been, we move over. The state now adopts the burden for them to show how the statute in question is consistent with our nation's history of arm regulatory tradition. All right, so I'm pausing this video for just a moment. USCCA, which is sponsoring this video, is doing a giveaway. And what they're giving away is really cool. Now, it does end soon, so you're going to have to participate relatively quickly. If you go into the descriptions directly below this video, you can find out all about their giveaway. Click on the link and go ahead and participate. All right, let's get back to the video. A lot of states have been attempting to attack that first prong, that Second Amendment analysis. And one of the arguments that they make is that the plaintiffs in question here do not fall within the people. And their argument, which is really kind of amusing, is that, well, the people are law-abiding citizens, and the majority of the people that seek out butterfly knives are criminals. And the Second Amendment does not apply to criminals. The justices completely obliterate that argument. They say, to suggest that because criminals carry arms, all people that bear arms are criminals is logically indefensible, okay? Just because criminals seem to have a particular unique interest in one particular type of weapon does not mean that all people that have interest in that weapons are criminals. So they thoroughly discredit that argument completely. The state then makes the argument that, well, the plaintiffs don't necessarily have standing, right? For a case to go before the court, there has to be an actual case in controversy. And these particular individuals who are law-abiding citizens, while they may want to purchase a knife, and while, yes, it is illegal for them to purchase that knife, they haven't actually done it yet. Therefore, they don't have standing. So essentially what they're arguing is the only way that they would have standing is to actually go out and break the law, be arrested, be prosecuted, and then challenge it that way. And the Ninth Circuit said, absolutely not. You can't do it that way. So that argument's been thoroughly discredited. Then they go to the Bruin analysis, to where we actually sit there and we look at the regulatory traditions, and the state essentially says, well, look, you got to give us more time. We have to do a more exhaustive, historical research on this. And the Ninth Circuit says, absolutely not. You've had more than enough time, and you've already done all the research that's absolutely necessary here. There is no regulatory tradition that bans the ownership or possession of butterfly knives or anything of that magnitude that existed in 1791. We're done. All right? They reverse and remand the case back to the district court level. Now, what's cool about this is something that I have been kvetching about for a number of months now. You might have seen in some of the videos that I've done where lower court judges have made the argument that the Second Amendment only applies to weapons that are in common use. We've heard this common use test. And then they completely misrepresent what Justice Scalia said in Heller as it relates to common use. So Justice Scalia said that weapons that are in common use for lawful purposes such as self-defense are protected by the Second Amendment. These other courts now, these lower courts, have reimagined what Justice Scalia has said, and they've essentially argued that the Second Amendment only protects weapons that are in common use for the lawful purpose of self-defense. They've eliminated all other forms of use. They've relegated exclusively to self-defense. And then they get into a granular analysis as to what self-defense actually is. And in their argument, self-defense is only the physical act of defending yourself against a criminal assault. That simply being prepared to defend yourself against a criminal act of assault is not sufficient self-defense. At least that's their argument. In this Ninth Circuit opinion, which is published, which is citable, and is now controlling legal authority, notwithstanding an en banc review, they say lawful purposes such as self-defense. Judge B does make the argument that the core purpose of the Second Amendment is to bear arms to protect yourself, against criminal assault. That self-defense is the core purpose of the Second Amendment. But it's not the exclusivity of the Second Amendment. There are other lawful purposes as well. So at least within the Ninth Circuit, we now have controlling legal authority that I believe is going to cut off that line of argumentation for lower court judges. We'll have to see how that ultimately plays out. So, does this now mean that the good residents of Hawaii can go out and buy their butterfly knives? Well, not exactly yet. It's been remanded back to the district court level, but ultimately it is going to be found to be unconstitutional. Again, notwithstanding an en banc review or an appeal to the Supreme Court. We'll have to see whether or not that actually happens. In any event, it is still fluid, but it is good and interesting law. And it's very rare, to be quite honest with you, that I get to say that the Ninth Circuit Court of Appeals got it right when it comes to Second Amendment jurisprudence. In this particular case, it certainly did. All right. As always, if you would like to email me, please do so at stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.